Morning. It's good to see so many people logging on actually for this webinar on the changes in inheritance tax, which is not a great surprise given the amount of press coverage that it's had. So my name's Esther Carter. I'm a partner at Moore Kingston Smith. Many of you are clients and will know who we are, but for those of you who are less familiar with who we are, Moore Kingston Smith is a leading audit, tax and advisory firm. We work with entrepreneurial businesses across all different sectors, as well as not-for-profit and private client. And we're also part of More Global, which is an international network with presence in over 100 countries. So very well placed to help our clients with their international expansion. So, like I say, this morning's topic is about the recent changes in the inheritance tax rules, which take effect from next April. Whilst the conditions around the relief haven't changed, it is now only going to be 100% on the first million and then reduced to 50% thereafter. So quite significant impact. So we've pulled together a panel of experts to talk about how we might do some strategic planning around that to minimise the impact of the changes. So we have Michelle Daly-West, who is a tax partner with Moore Kingston Smith, Blair Gold, who is a solicitor with us and a director at Moore SGD Law, and Tracy Che, who is a financial planner at Moore Kingston Smith Financial Advisors. So before we start then, and I'm going to lightly chair this and ask the panel some questions, but it'd be really great if we could have a bit of audience participation, so do feel free to pose your questions as well. This webinar is for you, want you to get the most out of it as possible, but please do put your questions in the Q&A function because it's much easier for me to keep track of than there. The session's also being recorded, so for any of your peers or colleagues who weren't able to make today, please do share it with them. And at the end of the webinar, we will be sharing a very, very short feedback form, and it's super, super helpful if you fill that in because it helps us to shape future webinars. So kicking off then, so we're going to start with you, Michelle, on screen already there. So just tell us kind of, what is business property relief and what are the proposed changes that are coming in that have gained so much attention in the press?
Yeah, it's definitely been something that's been talked about a lot more recently. So for those, I mean, I'm sure most of you are already aware that, business property relief is an inheritance tax relief. So in the absence of any reliefs or exemptions, inheritance tax would be charged on your estate at 40%. And what business property relief does is currently, if you've got assets which qualify for business property relief, you will get either full exemption or 50% exemption. I mean, what we're going to be talking about here is probably the impact on that 100% exemption, because that's the part that's sort of mainly changing. So currently, any sort of shares in trading companies which qualify for business property relief will get that full 100% exemption, regardless of the value. It could be worth $1 million, it could be worth 100 million. You will get full exemption in your estate. So these rules that are coming in are a massive change and they are massively costly. And so I think it's just worthwhile bearing in mind that if you do have assets more than £1 million, you need to be looking at this, because what the rules have done is they've now capped the rate of relief. So again, I've got a brief example to illustrate this. If I just bring up the slide quickly, I will show you all. Right, so what we've got here, so if I just, it's probably the best way to illustrate this by this example here. So we've got an individual who owned a trading company worth £5 million. So we're going to make the assumption here, we're not going to go through the conditions of business property relief, we're going to assume it qualifies. The only word of caution I would give is if you've got your own trading business and you've got something in there called accepted assets, and that's generally things of investment in nature. So it could be large cash balances, it can be, you've reinvested profits into, say, an investment property. Take a bit of caution here, get some advice to ensure that you are qualifying in full. But anyway, if we take the assumption here, this trading company is worth 5 million, qualifies in full for business property relief. So again, it's important to note that under the changes, which I'm going to go through in a second, the definition of business property has not changed. That remains the same. So let's move on a little bit. And unfortunately, the individual who owns the business dies. So where are we now? So under the current rules, as we've already said, the trading company will qualify for business property relief. At the moment, so before the 5th of April 2026, the rate of relief will be the full 100% on that 5 million. So what this means is if the individual dies, the assets go into the estate, they don't pay 40% inheritance tax, there's nothing to pay. It is fully exempt. So there is no inheritance tax due. So a lot of people have done their sort of estate planning on the basis that they've got business property, it's going to qualify, I don't need to do anything with it, so I can just sort of leave it alone alongside things. But from 6th of April 2026, the position is very, very different. So again, we've still got a qualifying trading company, As I said, the definition of business property hasn't changed, so it will still qualify for business property relief. But the main change is that it's now that 100% relief is now restricted to just the first 1 million. Thereafter, what it's done is not completely gotten rid of the relief after that million. What it's done is reduced it to 50%. So at the moment, business property relief, you get 100% or 50% depending on type of asset. But again, for shares in a qualifying trading company, we are currently at 100% regardless of the value. So this is quite a big change for these kind of assets. And many of you out there, I'm sure, have your own trading businesses. You've built them up. They are, you know, your livelihood, and you want to pass them to the next generation, and we're not expecting to have to, you know, potentially foot a tax bill. So these changes are quite revolutionary in the industry. So what this means is now, so you get the 100% relief on the first million. Thereafter, there is still relief, but it drops to 50%. So effectively, the way this works is that you will effectively, on the value of business assets, more than 1 million in your estate, you'll be paying inheritance tax at a rate of 20%. That's the way the numbers kind of work as you work things through. So taking this example here, on this 5 million, there is now £800,000 of tax to pay. So by virtue of doing nothing, this individual who has died, just by dying, like hopefully we all die past 6th of April 2026, but by, you know, going into those new rules, there is an increase of £800,000 just like that. So it's really important that if you have business assets worth more than 1 million, you are looking at it. But a couple of other changes I want sort of points to note is that, so based on the current proposals, this million won't transfer to your spouse in the same way as the usual nil rate bands, which again is not a positive change, because it now requires some action to ensure you are benefiting as a spouse to get your 1 million as well, if you don't already own shares or the business assets. It's also important to note this is a shared threshold with agricultural property relief. I'm sure a lot of you have seen in the press that we've seen a lot of lobbying and everything else with the sort of farmers about, you know, let's abolish the family farm tax. These rules are exactly the same. So if you have agricultural assets, you are sharing that 1 million with that, so you don't get 1 million for each. And I think also it's just worth pointing out the one concession we do have is that if inheritance tax is due on business property relievable assets, then the tax can be spread over 10 years tax-free. So that's the one positive we have.
Well, that's good. That's helpful, isn't it, Michelle?
Yeah.
So I mean, maybe just coming to you now, Blair. So I mean, obviously, lots of people have a will that would generally kind of leave their assets or their estate to their spouse. So do people need to be reviewing these wills? Do these wills need to be amended? And are there any other sort of business succession documents that might need updating in light of the changes?
Well, the simple answer is yes. That it's really an opportune time now, really, for us to speak to clients and really get to know them and get to know what matters they've put in place in their wills or in any other trust arrangements, because it's been, as Michelle said, it's quite a seismic change in relation to the landscape of advice where we normally advise clients. So business property relief was always the go-to to earmark and to keep safe from HMRC really taxation for a few generations, that sort of space really. So I would encourage all of us really to reach out to our clients and really discuss things like what's the state of play with their wills. Often it can be mirror wills, sometimes between husbands and wives, sometimes they can have business trusts within the wills, and sometimes they're discretionary will trusts. So there are different means and ways in which we can try to safeguard business assets going forward. But as Michelle said, it's really about timing, really. We've got that April 2026 deadline, and we know that the business relief that was once 100% is now being reduced down considerably. So really what we need to do is encourage people to come and speak to me or Will within the private client team, and really just kind of reach out so that we can look at the documents and make sure that they're as good for purpose as possible, because the whole point is we're trying to protect those farms, protect those businesses from the hefty taxation that will come on first death, which is obviously was something unexpected and something that we're trying to work towards now and help people with.
Thanks, Blair. Tracy, there's a lot of talk about insurance policies, isn't there? We're going to have these much increased liabilities, albeit we might be able to spread them over the 10 years. But is there a way that we can use insurance policies to sort of try and mitigate some of the burden?
Yeah, the short answer is yes. I mean, insurance policies have always been in place and have been a really important part of the planning, but even more so now it's coming to the forefront because when, there needs to be liquidity. For example, if a shareholder passed away, shareholder protection is a really good way of providing liquidity for the business to cover that, to basically buy out that shareholder's share. So if we use this example on £1 million cover for a shareholder that's age 45, the monthly premium is only £62 a month. For someone a little bit older, at age 60, that goes up to £202 a month. So if you think you're planning a business exit in 5 years, you only need to take out a 5-year term. You can write the cover into a business trust so that it's outside of the deceased estate if it kicks in. And it's a business expense, so you can just put it through the business, but it is a P11D benefit, so what was more commonly known as a benefit in kind. So it just provides a really efficient way to and cost-effective way to make sure there's liquidity at the right time for the business. It allows the remaining business owners to retain control of the business and provide liquidity to the family at a time of need. If we fast forward 5 years and think, okay, now the business exit has happened, actually, as soon as the proceeds hit your personal bank account, it then increases your own inheritance tax liability. So then we have to think about personal cover. So again, using an example, if there's a £1.5 million inheritance tax liability, considering your personal assets as well, for someone that's age 68, non-smoker and good health, sometimes people think immediately, oh, I've got a 1.5 million inheritance tax liability and I need a whole of life policy to cover that whole amount. That works out to be about £3,300 as a monthly premium. But it's important to speak to an advisor at this point because actually we need to work out what are your objectives, do some inheritance tax planning on your personal assets essentially, and consider whether a guaranteed premium is the most appropriate one, or whether actually there will be some changes in the future. That means that you might not need all the cover. You need the cover from day one, but the amount of cover that you need might change in the future. If you plan on, for example, making lifetime gifts, then perhaps a reviewable premium is more appropriate, which is comparatively a lot cheaper to start with. Or maybe it's quite imminent that you're going to make large gifts, so a term insurance might be more appropriate. As the screen shows, for the same £1.5 million cover, if we work out the different objectives and match it to the correct type of policy, it can actually reduce that £3,300 monthly premium to roughly £1,900 a month, which is quite a large difference monthly ongoing, but it needs some consideration and planning involved.
Thank you, Tracy. And are we seeing lots of clients take these insurance policies out? Because they do seem quite good value if an insurance policy can be good value.
Yes, I mean, pretty much every single client that I'm talking to is considering this a lot more at the moment and taking up on that, yeah, for sure.
Yeah. Thank you.
Yeah, so from a tax planning point of view, it's very useful to have a policy in place. Obviously, it pays outside the estate, and it can pay to non-spouse to be used against any inheritance tax. So as Tracy said, it's very good for mitigating that huge tax burden potentially when somebody passes.
Yeah, no, absolutely. Had a question come in. Does the spouse get the £1 million tax-free as well if they hold shares in the company? It said here, interesting, if she, but I'm going to say they because it could be either way.
Can I answer that one? So yeah, if your spouse also holds assets that qualify for business property relief, then yes, they'll also get their 1 million. It's just worth being aware that for everybody, your 1 million limit is capped to you. It will refresh every 7 years, which is more relevant to gifting, but it's just being aware that so everyone will get that 1 million. What's important, I think, to Blair's point earlier, is that you need to ensure that that spouse has the assets in order to use the relief. So let's say you've got a husband and wife. And let's take the tradition. Let's take, so the female owns the business in this case, and the husband doesn't. And actually, say husband passes first, If he didn't have any of those shares, then he's lost his relief. So this is why it's important now to look at your shareholding structures and sort of your wills to ensure that things are passing in the way you expect them to, and everyone actually is, where possible, maximising that 1 million relief each. So yes, you do get it, but you need to make sure you hold assets that qualify in order to make use of it.
Yeah, you have to use it or lose it. So it's very important that we recognise that now, because it's a bit like the old pre-2007 no rate bands, where if they weren't used on first death, then they would be lost. So it's inequitable in some ways, but I know that we as a firm have made representations to HMRC on this basis to say it's unfair, and we'll see. There might be changes afoot in April 26 when they enact the changes, but as Michelle and Tracy say, that you know, we have to be aware of the fact that we have to try and earmark it on first death.
Are there qualifying periods for the length of time they would have had to have held those shares? If people now are thinking, oh, I shall gift some shares to my spouse, we make, you know, use of 2 lots of $1 million, is there a qualifying time period that they had to have held them for? Because
yeah, there are certain
$1 million
conditions that need to be, there are conditions that need to be met, so you need to look at that. But essentially, between spouses, it's a lot more fluid than it is for gifting to other individuals. But typically, for business property, it's a minimum 2-year holding period. So again, it's important that planning is being looked at now to ensure that, you know, because in the situation you have a lot of couples who live together, not spouses, but they're cohabiting and have done for a long time. So you want to make sure that you're doing everything you can to secure the relief across, maximising across the family, even if it's not, you're not married.
And you talked about that $1 million refreshing itself after 7 years, obviously only relevant for gifting. You can't die twice. So if you were to gift $1 million, then after 7 years you would still get your $1 million exemption on the business property relief.
Yeah, that's correct. So yeah, if you make a gift, it's sort of still potentially within the scope of inheritance tax. If you don't survive within 7 years, slightly different if you're gifting to a spouse. So if you were then sort of to pass away, then they'd look at previous gifts, and so you could potentially use some of your limit already because you've made an earlier gift on death. But then after 7 years, if you've died 7 years, that look back only goes to that 7-year period. So if you've gifted a load of business assets, say 8 years before, you can kind of ignore that. So again, depending on the value of your business, you could make a lot of headway by doing gifts periodically to try and use your 1 million every 7 years and keep moving it on. I mean, again, depending on the value, it might not make a huge difference, but for actually quite a lot, I think a lot of businesses are around, you know, that sort of 2 to 10 million mark that we deal with. And so actually that can be really effective over that period of time.
One thing I would add to that point is that if you've gifted into a trust, of course, you go back 7 years, but then you have to go back another 7 years. So depending on the nature of the gift, really. So just be familiar with that, really. The 7-year rule usually applies for gifts between people, or if you put things into trust, then you have to go back a bit further just to mop those up as well.
And just to jump in there as well, a lot of times for clients, they're concerned about gifting too early. So I think that here is where cash flow planning really comes into play. We can build a cash flow model, basically completely bespoke to your circumstances, and modelling if you gifted every 7 years £1 million each, how does that look? How does that impact your financial security? We can model scenarios such as if you went into care, how does that impact you know, your overall wealth, and how much can you actually afford to gift? So I think it's important considering gifting, but also considering your own financial security first.
A couple of questions come in. Somebody said, using Michelle's example of inheritance tax being 800,000, they assume this is payable by the estate. If the funds to pay the tax are in the company, then how should these be withdrawn in the most tax effective way?
Actually, and that's a really good question, because this is one of the big problems with these rules that are coming in, because unfortunately the money has to come somewhere. And depending on the way, the will may well be drafted to say the tax comes from elsewhere in the estate, which if there's liquidity in there, that's actually probably quite a good thing. But if there's not, and you've got a business, and say the only asset is the business, that's where it's coming from. Unfortunately, it's going to have to come out of future profits from that business. And so you'll be looking at the sort of usual remuneration strategies and looking at the sort of the circumstances surrounding the business. I mean, there could still be loans outstanding to individuals, which is a much better situation. But I think what we're foreseeing is that, unfortunately, the position at the moment is that individuals who are having to foot this bill after the business owner's died are going to have to take it out of like profits from the business as you pay tax on that. At the moment, there is no right answer to make it the most tax effective. It's going to depend on individual circumstances. And so this is just, yeah, this is something that's causing a lot of people a headache, because if you've got a business that's illiquid, you know, they don't pay dividends, they don't get that cash, but where's it going to come from? I think this goes back to Tracy's point. It's really important to look at ensuring this where you can, because you could potentially leave in your future generations, you know, run your business and suddenly there is no money to come out of it for them for a very, very long time, at least not personally for them to keep. So I think it's just really important.
Yeah, I mean, obviously they've got the 10-year period to pay, but that may
Yeah.
not be of use if the business is completely illiquid. So it is a big problem, hence, I guess, all of the uprise against the rule changes. Got a few more questions, but maybe I'll move on a little bit and come back to those. So I guess a question to all of you, really. I mean, a lot of people with children will say that their children are going to inherit their business anyway. So do they need to do anything? So are there sort of, what are the pros and cons of giving it to your children now?
Yeah, I mean, if I sort of take this initially, I think, I mean, one of the biggest benefits is actually, on the face of it, it's actually one of the most straightforward things to do, is just to give it away now and sort of get rid of it. The only thing I would sort of caution on that from a tax perspective is that whilst it does seem simple on the face of it, it is important that you do ensure it's implemented correctly, because when you give an asset away, again, without any exemptions and reliefs, that is subject to capital gains tax. And so whilst with a business asset, there are reliefs available to ensure you're not paying that tax at this point in time, there is paperwork to do, various, you know, claims and elections to make. So it's important that's being done properly, because what you don't want to do is end yourself up with, yeah, an inadvertent tax bill. And there are also some other implications need to be looked at as well. I think it's also worthwhile bearing in mind, we've touched on this briefly, is that this 7-year rule when it comes to gifts, is that if you're not making the gift to your spouse, you know, you need to potentially survive that full 7 years before it's completely outside the scope of inheritance tax. So again, I think this goes back to Tracy's point earlier, is that if you're making a gift, I believe there are premiums available where policies available where you can insure a particular gift. So it's much more of a term insurance where you cover that off. And again, it's just making sure you're making the gifts aware of all the implications, because what you don't want to do is create yourself not necessarily a bigger problem down the line, but add complication that you just weren't expecting, when a little bit of planning can actually deal with that quite effectively.
Also, you've got to be mindful of the children and their particular circumstances. If they're going through a divorce or they're bankrupt or suffering from all kinds of other issues, that be mindful gifting to them may not be the most opportune at that time, may not be the best option. So just to kind of be aware of the holistic nature of the family, really, and the individual personal circumstances of each is very important to glean when we speak to clients. It's just to find out exactly where they stand and how they stand, and the interrelationships between parents and children, very important.
Yeah, and I'd probably from my part, I'll stress again the considering your own objectives first, your own financial security first. How much can you afford to give? Working out how to gift, all quite important. Cash flow planning again. We can, you know, look at different scenarios and just give that peace of mind that, okay, if I gifted this away, I absolutely don't need it, because once you've gifted it, you know, there's no going back from that. So
However much your children love you, they're probably not going to want to give it back. What about things like shareholders agreements and partnership deeds? Do we need to be reviewing these and potentially making updates to reflect the changes?
Yeah, from my point of view, I think just a general MOT of all these documents, so you have a good look through all of them and make sure that they're as compatible with the changes as possible, really. I think that we know that certainly within the corporate team and within the legal space within MKS, we've got all the talents there to deal with shareholders agreements, resolutions, and any changes that may be needed. But you know, I certainly think it's again, it's down to the individual personal circumstances of the family. But yeah, a general review is very, very important, I think, in advance of April 26.
I mean, we've talked about sort of gifting to spouse and children, but sort of generally speaking, do we think there's benefit of transferring business assets now rather than after the legislation takes place? It's kind of who, and it's the timing of when, isn't it?
Yeah, it's always a tricky one, because gifting is fine. It will potentially save tax, but it's about relinquishing control. Many families need to. They may have a patriarchal family business. dad might be in charge, or somebody, you know, who may not want to relinquish control. So it's very important that we get a feel for why, what they should do, of course, is to think about gifting to children. But you have to work on the family circumstance, whether somebody wants to do that. We always say, don't let the tax tail wag the dog. It's true with family businesses. Sometimes dads do not want to give up control. Maybe they have other reasons for hanging on to it. And they have to just, you know, be reassured that that's an option, but it's possibly not the best tax option. But certainly gifting is something that we can deal with, and certainly happy to help with that.
And what sort of the tax analysis if we were to gift between now and when the changes come in? Are we sort of under new rules or old rules, or what's the deal there?
So, well, if you make a gift now, so before the 6th of April, then you're currently under the current rules, but there are some anti-forestalling sort of provisions in place whereby the current rules will apply up until that 6th of April 2026, and then if you pass away after that, unfortunately, you're then brought into the new rules in terms of the actual tax exposure on your estate. However, gifts made already before 30th of October 2024, when the proposed changes were announced, are kind of effectively fully protected. They're fine. It's just, so you've got this kind of interim period where you may fall into the new rules, but again, doing something, if you're able to give them away, it's the right thing to do for your circumstances, is better than nothing, because at least you're setting that 7-year clock running now and hopefully fully outside the scope.
Yeah.
And presumably these changes are going to massively affect any current planning that's been done within trusts.
Yes, unfortunately so. So I think anybody here who has any involvement with the trust or knows what, if they're paying with trust, we know it's very, very complicated already. And these rules just add another layer of complication, unfortunately. So what's important to know is that if a trust currently holds business property, it currently gets sort of full relief in a very similar way as for an individual. But under the new rules, trust will also be subject to this £1 million of relief. So there's potentially tax that could be levied. So the way tax charges work on sort of most trusts is that every 10 years there will be a tax charge. And under these new rules, the way this kind of works, once you've used your 1 million in that trust, you could pay a tax charge in that trust of up to 3%, which is very different to the 0 you're paying now. And again, that can become quite costly over a period of time. But it's remembering that it could potentially be every 10 years. But under the current rules, there would be no tax if your assets are qualifying. But I think it's worthwhile pointing out, so for existing trusts those that already have business property in them before 30th of October, so on those assets, you actually don't come into these rules quite as quickly as everybody else. So whilst the new rules do kick in from the 6th of April next year, it will be on the first, or your next 10-year charge will be the time it sort of kicks in. So if you establish a trust, I say a month before these rules were announced back in October, then you've potentially got 9 years on everybody else before the rules, tax charges become payable within the trust, which gives you a lot more time to do some of the planning. But so yeah, unfortunately, that's sort of luck of the draw as to when you establish a trust and put the sort of property in. But I guess so, yes, it does affect existing planning, but it's also a very good window of opportunity to do some planning now, because the new rules potentially don't come into effect until the 6th of April. At the moment, gifts into a trust of business property do still qualify for full relief up to that point. So you can still get them into a trust, and you can weigh up that position whereby, okay, do I keep the assets in my estate and potentially pay 20% inheritance tax, or the effective rate over and above that 1 million, or do I put it into trust knowing that every 10 years I'll be paying the 3%? And I think it's going to be looking at your circumstances, your family circumstances, as to whether a trust is appropriate in the first place, but also weighing up that tax benefit. But I think it very much goes back to Blair's point earlier, don't let the tax tail wag the dog. It's considering your personal and family circumstances to work out what's right for you. But there are definitely some really good planning opportunities at the moment with trusts that can be looked at. Although appreciating that for existing trusts, it does add a layer of complication, which hasn't been welcomed by anybody, let's be honest.
But we within the legal team, obviously we support Michelle and Tracy and everybody really in relation to the drafting of discretionary trusts or discretionary will trusts if we're drawing up a will. And there are different ways of doing this and registering them with the trust registration system. So we deal with all of that within our space, and obviously if anyone has any clients who feel that would be benefit by our input, then feel free to send them over.
And we need a bit of crystal ball gazing here, don't we, as well, when we're deciding whether, you know, which route to go down. So yeah, all crystal balls welcome. What about sort of business property relief changes and interaction with powers of attorney and probate planning? Presumably there's a whole minefield there as well, Blair.
Yeah, it's look, I think powers of attorney are really good, and I think they offer many benefits. And once the donor, the person who gives the power is the donor, and the people who receive the power are the attorney. So you can either limit or make open the powers of attorney depending on your personal circumstances. We're dealing a lot more now with business powers of attorney, which kind of keep within the framework of this talk, really, because we can either enable the donor to give power to attorneys to look after bank accounts, property details, you know, whatever, or we can keep it within the business structure. So you're only dealing with business matters, which would fit within the business team and within the kind of business regime advice that they may be receiving. So as far as LPAs basically work very well. Just check on them to make sure there are no limitations, because if there are, that might impact on the ability to deal with those assets and put them into trust if need be. And remember that the LPAs should only operate when somebody loses capacity. That's the principle behind an LPA. Although you can use an LPA, property and financial affairs, straight away once it's been registered. We recommend that they don't, but they can be used straight away, whereas health and welfare LPA can only be used if the donor loses capacity. So there's a kind of a difference there. But as far as the property and financial affairs LPAs are concerned, they can be used, but they need to be checked and ensure that they are compatible with the business interests that the donor has.
Super, thank you. Right, I'm going to go back to some of the questions that were asked earlier before we go on to a couple of wrap-up questions. So somebody's asked, if there's a lifetime gift of $1 million worth of BPR shares to a spouse, does he or she have to they've said here, have to survive for 2 years to get BPR on death?
Do you want me to take that one? Sorry.
Yeah, I would say
Yes.
probably probably one for you, Michelle.
To be honest, I would need to check on that one. I believe for spouse it's a much more relaxed, but I would need to check because normally the rule is 2 years.
Yeah. Okay, but maybe for spouse might be less. Okay, we'll come back to you directly on that one. Who was the person who asked the question? And then the other one that says, my client is selling his business over a few years. He's receiving 200,000 over the next 5 years. Does he need to pay any tax at all when transferring this 200 grand to his personal account? I'm not quite sure I understand the question, to be honest. I think we might need to come back to you specifically on that one because it's quite specific. This one's about UK companies being housed in an offshore trust. Will you now have a 10-year charge on that? We talked about the 10-year charges in trusts being 3%, but whether that will be the case if a company is in an offshore trust?
I think we'd have to check on that one, Esther, because as Michelle said, when you put anything into a trust, it's sort of ring fenced, and there's often tax going in, tax coming out, and then there's the periodic charges over the 10-year period. But I know that we deal with some more group, and they deal with Jersey and sort of the Channel Islands. But I can't be entirely sure. I'm not entirely sure quite how the foreign trusts operate.
Okay. Yeah, I would say back Blair up on that. I think with offshore trusts, the rules are very complicated, and you can end up with a lot of what feels to be inequality, and a lot of tax hits now because of a lot of the anti-avoidance rules that have gone in and everything else. So again, it's going to be very specific to your circumstances. Whether or not that's the inequity is likely to change, it's hard to comment at this point in time, unfortunately.
Yeah, I mean, from a very helicopter view, it seems that offshore trusts. I mean, not that HMRC never loved them in the first place, but they sort of seem to have fallen out of favour with HMRC a little bit more. So I imagine they're only going to make things more difficult with offshore trust planning rather than easier.
They don't like it.
No, they definitely don't. And somebody's asked, if a husband and wife company, do we need a shareholders agreement? And they said, I guess so, as you never know what might happen down the line. I think that's probably absolutely the answer. You never know what will happen. So I think, yes, you would need, in an ideal world, a shareholders agreement. I don't know if you've got any thoughts on that, Blair.
Well, I think so. Yeah, it's a shareholders agreement obviously sort of stipulates exactly what could happen, and you can sort of preserve and protect the integrity of the business going forward. So yeah, in essence, I think a shareholders agreement is a positive. And obviously within the legal team we'll deal with resolutions and shareholders agreements, the backup company articles and terms.
Yeah.
It fits in. Sorry, just kind of slightly taking away, but the business LPAs that we also do, we sometimes include within sort of an accompanying shareholders agreement that would make, and then we check the articles and memorandum to make sure that they are compatible with the terms of the company, you know, and so yeah, so useful on that point as well.
Mm-hmm. I suppose a bit more of a sort of general question. I mean, given the backlash that there's been and the amount of press attention that it's received, you know, do we think these changes are definitely going to go ahead? And so, you know, do we need to proceed with caution with doing lots of tax planning now in case they don't go ahead? And how would that be dealt with?
Yeah, I think we can probably always say with certainty these changes are going to go ahead in some form. We don't quite know the detail what it's going to look like yet. So, I mean, the changes were only announced back in October last year. At the moment, they are proposed changes to kick in from 6th of April. HMRC did launch consultation back at the end of February. That consultation period is now closed. So it changed comes at the end of April, where actually a lot of professional organisations did feed in their comments on the proposed changes. But what I will say is that consultation was very much more based and talking about the impact on the changes to trusts. So we don't know what else is going to come out, but what we're expecting is feedback from that consultation later this year. And I would imagine that, you know, draft legislation will come out at some point towards the end of the year to be able to tell us actually what these changes are definitely going to be. So I would say almost certainly, yes, the changes are coming in. Are they going to look exactly like we're describing today? Possibly not. I mean, the biggest representation that's been made across many firms, I think Blair mentioned this earlier, is this 1 million being transferable to your spouse, because it does seem yeah, a complete nonsense. And going back to the question earlier about that 2-year period, I do believe that even if it goes to spouse, you've still got to hold it for that 2 years. So it is just that planning does need to be put in place. So it's kind of, it's very much, it depends. And in terms of the planning, I think a lot of the planning that can be done right now, ahead of known definite changes are, like even updating your wills and things, they're quite minor things that can be done to get that easy win. And doing it now isn't going to impact, if it's done in the right way, it's not going to impact if these rules come in slightly differently. We're doing, you know, the right way. I think it's frustrating we haven't got all the answers right now. I think it goes back to that crystal ball you were talking about earlier, Esther. But we are expecting, I mean, it's the lobbying, I think, for agricultural property relief has been the biggest thing, whereby I think we all heard about the tractors coming down Westminster, you know, to come against this. And I think that's where a lot of the attention's been. So my gut feel, and this is only my personal view, is that if we do see significant change to the proposed rules, it will be to do with agricultural property rather than business property, would be my expectation.
I agree. Actually, we see a lot from the farming community coming forward and sort of protesting, but not so much from the business community. When in fact businesses, I think, are going to be much more impacted on than basically the farming industry in some ways, because there's many more businesses that will they'll probably fall under this new system and will need to be relooked at and advised accordingly. So it'll be interesting. But as Michelle says, it's enacted in April 2026. That's when the law will be clear. So we'll know a lot more then. And in a way, I guess we're just having to work on the basis of what we know now. And it would be remiss of us not to advise on what we know now. And hopefully some sense is seen in April, and they will revisit some of the proposed changes, and we'll see. We'll have to wait and see.
Yeah, no, thank you. I mean, we've talked a lot about business property and shares in businesses. What about once the business is sold? Presumably that's a whole different set of considerations then.
Yeah, so I think the thing to flag here really is that from the moment the business is sold and you receive that cash proceeds into your bank account, the business relief is gone. It no longer applies. You don't have it in a qualifying asset. So actually your inheritance tax liability will more than double immediately as you lose the £1 million that's at 100% relief. And for businesses that are worth more than that, the 50% thereafter. So really we need to consider your personal circumstances as a whole. What other assets do you hold in your personal name? So usually that's, your main residence and any investments. To touch on other changes that are that was in the last budget, pensions are also being brought into the IHG regime. So thinking about all of that, you might need to consider putting some personal protection in place to mitigate that liability. Previously, this could have been funded by the business through, for example, the shareholder protection, etc. But post business sale, that will have to come from, in your personal names. There are also business relief qualifying investments that you can consider. If it's invested within the last 3 years of selling the business, it will actually be re-qualifying it immediately. It's called replacement relief. So even if you had proceeds that didn't come from a business sale, usually, as Michelle's mentioned earlier, it takes 2 years for it to become qualifying. But the beauty of selling a business is that you can get that qualifying, you can re-qualify that immediately. Obviously, it needs to be recommended by a financial advisor. Make sure that it's suitable for your circumstances. Make sure the risk is that you're taking is the correct amount for you personally. And I'd recommend that you start speaking to one if you know there's an upcoming exit about 6 months before, because these things take time to kind of work out.
And
Yeah,
actually,
I
can I
think-
add to that, Tracy? I think it's really important you mentioned about that ability for it to qualify immediately. So I think not a lot of people realise there is this, the ability to reinvest funds quite quickly, and that's where it can get quite complicated, where the 2-year holding period suddenly isn't as relevant as you thought it is. So it's definitely worthwhile getting your position looked at to understand what the options are, so you don't miss out on doing something when actually you could have just done something quickly.
And I guess the advantage when we was talking about the allowance not being transferable between spouses, actually once you've got cash proceeds, you can easily just put £1 million of business relief qualifying investments into each spouse's name. So immediately that makes it a lot easier to deal with that, rather than whilst it's in a business and you've got to change all the shareholder agreements, etc. as well.
On that, Tracy, if you have a sort of spousal mirror will between two spouses and the one spouse dies before with business property, we can always do a deed of variation to maybe house that £1 million with the business property relief in advance of distributing the estate. So if we can act now on deaths now, so we can still earmark. Deeds of variation are very good as long as everybody's in agreement. We can vary the will of the recently deceased to deal with any business property relievable assets within that estate. So another conversation we can have with clients.
Yeah. Well, it sounds like planning is the key, and to make sure you're having all the relevant conversations with, people with tax expertise, legal expertise, and financial planning expertise, for example, the people on this call. So yeah, I think start thinking about things way ahead of when you might be leaving this earth, rather than leaving things to the last minute, and buy a crystal ball as well. So, well, thank you very much, everyone, for joining us. Hopefully everyone's learned something from that, and we've got a few questions there. We'll come back to you specifically on those answers. Please do fill out that feedback form. It's really, really short and super helpful. And no doubt we will see you again on one of our future webinars. Thank you very much. Enjoy the rest of your day.